I am extremely grateful to the members who have spoken. In fact, it's very rare, as I said, that a law made in 2013, we have to review it, because it's a bill with 470 provisions. That's the Act. And therefore, a lot of representations had started coming the moment this Act was notified. There was some drafting oversights, because it's a long Act, plus some inconveniences were felt when the Act was being implemented. We therefore held consultations with all stakeholders, and we were able to identify several points which required to be revisited. Some of those points were revisited by virtue of notifications or even rules. For example, one of the issues that Naresh Agrawal ji has raised with regard to a large number of private sector, limited companies, the provisions of very onerous nature being made applicable to them. Now, by virtue of a notification, it was possible to give private limited companies exemption from some of those provisions. And therefore, those exemption notifications have been given, and the pain of some of those provisions has been diluted by that particular process. Now, I was initially able to shortlist 14, and then 2 more have been added after the bill was passed in the Lok Sabha. Provisions which had to be brought in at line with the international standards. Now, the question which was asked is, why are we in a hurry? Because, as Premchand Gupta ji rightly mentioned, people are finding it extremely inconvenient after this legislation to comply with all the provisions, and therefore are finding out devices of not forming a company and going in by other devices, including a limited liability partnership, whether that will be a better option to do business in rather than a company registered under this Act itself. For example, I had mentioned, if we see section 212, subsection 6, for some reason we have to be careful of this whole process. About 4 years ago, even in the Customs Act, this provision was brought in. So a provision for bail, which was considered very onerous even for an anti-terrorism law, is brought in for a violation of the Companies Act. So it was earlier brought in for the Customs Act, then the then Finance Minister, I had pointed it out to him, had withdrawn it. Now, this is an onerous provision, so except in very serious cases of fraud, I have amended that provision, and the normal provisions under the CRPC will apply as far as bail is concerned. Now, the provisions which are being amended, some of which were referred to by Rahman Khanji when he spoke. Now, this mandatory capital limit, globally now it is being considered as obsolete provision. So, world over we have seen all the corporate laws, they don't have a provision as far as this is concerned. Similarly, the whole idea of a company seal, it has also now started becoming almost a relic as far as global laws are concerned. So our law is being brought in with this level. The third amendment relates to if there is a prohibition on accepting deposits and a company violates that and still accepts deposits. So the provision was enacted, but punishment for violation they forgot to put in. So that gap has to be filled up by virtue of the amendment. The next provision is with regard to inspection of records of companies. Now, AGM resolutions are meant for public display, but board resolutions are not. A board resolution of a company may actually contain, you have a private company or a public company, its entire corporate strategy may be contained in them, its the manner in which its financial strategy may be contained in them, its intellectual property strategy will be contained in them. This is going to be the name of my product, this is going to be the patent that I am going to ask for. Now, those are not available for public display anywhere. So, this Act obliterated the distinction between a board resolution and an AGM resolution, so the correction had to be done. Now, there was another lapse which had taken place. There was a provision for setting off past losses and depreciation before declaring dividend. So if you have accumulated losses, first you account for those accumulated losses, only then the shareholders get dividend. Now this provision was put in the rules without being put in the Act. So the gap as far as drafting is concerned has to be rectified. Similarly, there is transferring equity shares for which unclaimed dividend has to be transferred to the investor education fund. Now the regulation, the rule is that for 7 years if dividend is not claimed, then that is to be transferred. Now there was a drafting error into this, that even if it is not claimed for 1 year, that is how the drafting came about. There was a little ambiguous drafting which has to be corrected. Now people make various kinds of allegations of fraud or some mistake, because fraud can be very widely defined. A fraud may involve only 20 rupees, it may involve 20 million rupees. So a threshold has to be provided that it is only the cases above a threshold which can be reported to the central government. Now there is a major provision I mentioned with regard to related party transactions. In fact, this is one of the provisions which has been complained of the maximum. Now, particularly in relation to a large number of companies where people, as was mentioned, are directors of multiple companies or their relatives or spouses are directors, etc. Now, instead of rule by majority, the criticism against this provision is it's becoming a rule by minority, because you won't be there and somebody else, the minority shareholders will have to vote on your fate. And the majority required is 75% of them by a special resolution. For the present, I am diluting it to an ordinary resolution, but I am accepting the suggestion which has been made by Shri Naresh Agrawal, Shri Naresh Gujral and others, that the act is so wide that even these 15-16 amendments may not cover the entire field, and therefore a committee with which we have representatives of the Company Secretary Institute, the CA Institute or some chambers, plus somebody from the department, a broad-based committee, to continue to go into this whole question for the next few months as to where the shoe pinches as far as this act is concerned, and this may not be the last amendments which we are bringing in. Now, besides the related party transactions, there is some exemption to be granted in related party transactions with regard to transaction between a company and its wholly owned subsidiary, because that's one entity itself. Now, even there are no minority shareholders in a wholly owned subsidiary because the principal company owns everybody. So that provision was becoming unworkable. Now, with regard to the bail provisions, except serious fraud where the tough bail provision will apply, in all other cases, the normal provision under the CRPC will apply. So if the offences are minor, the courts will grant bail. If they are not minor, the courts will not grant bail. Now, all winding up cases to be heard by a 3-judge bench. Now, anybody who knows our judicial structure, 3 judges benches are constituted only when there are very serious, complicated questions of law. We call it the full bench, and in every court it's constituted very rarely. Now, for winding up a company, to go to 3 judges is too complicated a procedure. That provision, therefore, I am altering. Similarly, all cases of Companies Act to be tried by special courts. Now, there may be technical violations. Technical violations are only liable for minor penalties and so on. So, if only serious offences are there, we have categorized those serious offences, only they will go to a special court. The others have to be tried by the normal magisterial court. This, sir, is the substance of these amendments. And I am grateful to the members who have spoken on this. And as I have said, I will be constituted a committee very shortly to go into other areas of this Act, so that other amendments which are required in this Act could also be brought about.
मैं सोचता था कि चोर रात को आते हैं, छुप के आते हैं, खिड़की के अंदर से कूद कर आते हैं, मगर मुझे पता लगा कि सबसे बड़े चोर खुले दिन में आते हैं, सबके सामने आते हैं और सूट पहन कर आते हैं।